It's always been amazing to me how jurisprudence pops its head up in the most unexpected cases. This case was an otherwise fairly boring case about technicalities. It began with a traffic accident which took place in Grundy County in Iowa in 2001. The accident involved a semi-trailer owned by the Anderson Erickson company. The general rule in Iowa is that a person should sue either in the home county of one of the parties or in the county where the accident happened. There's a separate rule that says that common carriers, including commercial semi-trailers, can be sued in any county in which they operate. The Richards sued in Johnson County, even though nobody involved in the accident lived there, and the accident took place somewhere else. They argued that it was proper for them to sue in Johnson County because Anderson Erickson trucks regularly operated in Johnson County. The other parties objected and the court, unsurprisingly, moved the venue to Grundy County, where the accident had happened. The plaintiffs then lost their case and appealed the earlier decision to move venues. The Supreme Court of Iowa based their appeal decision on a much earlier precedent established in the 1920s. Essentially, they said that although the company was suable in any county where it operated, that didn't mean that each of those counties was necessarily an appropriate place to sue in any particular accident. They were invited to reverse that earlier precedent, but declined to do so. One of the explanations they gave was that when an interpretation or a precedent has been in place for a long time, in this case roughly 70 years, and has never been reversed by a court or by the legislature, the mere fact that the law has been left undisturbed is an endorsement of that precedent. To support this, the courts quoted Professor Ronald Dworkin, one of the great jurisprudence scholars. In the book Law's Empire, he said, "A statute owes its existence not only to the decision people made to enact it, but also to the decision of other people later not to amend or repeal it. It follows that one aspect of the doctrine of precedent is to consider how old and established the precedent is. The more established the precedent, the harder it will be to disturb."